Good morning. I am Dr. Harpreet Kaur, Professor of Law at National Law University, Delhi. Today I will be dealing with Module 8 on the course of Competition Law. This module is about unfair trade practices and restrictive trade practices. The objectives of the module is first of all to understand what are these practices, restrictive trade practices and unfair trade practices, and how they are restrictive for trade or for the flow of supplies in the market, or how they are unfair to the consumers. And we will also see that I will be dealing these two types of practices under the MRTP Act, Competition Act and the Consumer Protection Act, and we will analyze that how they are dealt by these three acts. We know that MRTP Act 1969 has been repealed, so how they have been shifted to Consumer Protection Act and how they are dealt with the Competition Act. So we will have to see that what is the difference between these practices under these three different acts and how they are dealt by them, and what is the focus or perspective of applicability of these practices under three different acts. So as far as the introduction goes on, any restrictive trade practice will include any practice which is restrictive in nature. So any agreement which is restrictive in nature will be restrictive trade practice, and whatever may be the restriction, whatever may be the nature of the restriction, immaterial of that, if it is restrictive in nature, it will be restrictive trade practice. Unfair trade practice will be a practice which is unfair to the consumers. So this is the scale on which we decide whether a practice is unfair or it is not. Now both these practices, they are trade practices, and both of them they are unfair to the consumers. So under this act, first of all, it is under this module, first of all it is necessary for us to understand what is trade practice, what is trade, and what is practice. So let us have a look at the definition of trade practice, which is given by section 2U of the MRTP Act. As I told you earlier that this act has been repealed, but we will take care of the act, because in order to make you understand the full concept of these two practices, it is necessary that you look into the background, the history, how the concept evolved, how it was earlier dealt, and how it is presently dealt. So under the MRTP Act, trade practice means any practice relating to the carrying on any trade and includes anything done by any person which controls or affects the price charged by or the method of trading of any trader or class of traders, or a single or isolated action of any person in relation to any trade. So this was the definition of trade practice. Let us now look at the definition which is given by the Competition Act. Section 2X of the Competition Act says that trade means any trade, business, industry, profession or occupation relating to the production, supply, distribution, storage or control of goods, and includes provision of any services. So over here you see that trade includes not only the word trade, but all the business, profession, industry, occupation which is related to production, supply, distribution, control, storage of goods, and also provision of services. Let us now look at the definition of practice, which is given by section 2M of the Competition Act 2002, and it says that practice includes any practice relating to the carrying on of any trade by a person or an enterprise. Now with this background, now we will start with the definition of the restrictive trade practice. So first of all, we will take care of RTPs, how they are defined under MRTP Act of 1969. So under section 20 of the MRTP Act, RTP was defined. It said that any practice which has or which may have the effect of preventing, distorting or restricting competition in any manner, a practice will be RTP. So three words which are used, that any practice which prevents, distorts or restricts competition in any manner, which will be a restrictive trade practice. And there are certain trade practices which are included. For example, when it tends to obstruct the flow of capital or resources into the stream of production, that means the production is hindered because there has been obstruction or a restriction on the flow of capital or resources. Second point, when it brings about manipulation of prices or condition of delivery or flow of supplies in the market relating to goods or services in such a manner that it imposes unjustified costs or restrictions on the consumer. So over here we see that it brings about, the practice brings about manipulation of prices, conditions of delivery or flow of supplies in the market which may be related to goods or to the services, and it imposes unjustified cost on the consumers. Now, in the case of Telco versus Registrar of Restrictive Trade Agreements, it was held that this definition is exhaustive and inclusive one, and whether a trade practice is restrictive or not, that can be decided only by applying the rule of reason. So, any restriction as to the area or price will not be per se a restrictive trade practice, but in order to determine whether it is a restrictive trade practice or not, certain tests have to be considered, and 3 points are main over here which have to be considered. First of all, what are the facts which are peculiar to the business to which this restriction is applicable? Secondly, what was the condition before and after the restriction is applied? And thirdly, what is the nature of the restraint and what is the actual or the probable effect of the restraint? On the basis of these three principles, only then we will be able to understand and make out or decide whether a trade practice is restrictive in nature or not. This was again observed by Supreme Court in the case of Mahindra and Mahindra Limited versus Union of India, that this definition is pragmatic and result oriented. Now, under section 33 of the MRTP Act 1969, certain registrable agreements were given. These registrable agreements, they fell in the category of the restrictive trade practices where the registration was compulsory. I will read these restrictions for you. First is agreement restricting or likely to restrict a person to whom goods are sold or from whom goods are bought. So, we are talking about buyer or seller and we are restricting them. Second, agreement with the condition for purchaser of goods to purchase some other goods, that is tied in agreement. Third, agreement restricting purchaser from purchasing or dealing with goods of any other person other than the seller, that is exclusive supply agreement. Agreement between buyers or sellers to buy or sell only at prices or terms and conditions which are settled between them. So, this is price fixation agreement. Agreement to allow concessions, benefits, rebate allowances, discounts or credits in connection with the dealings. Agreement of sale requiring the buyer to resell only at the prices which are dictated by the seller unless the buyer gets the right to sell at prices lower than those dictated. So, this is resale price maintenance. Then agreement restricting, limiting or withholding output or supply of goods or allocates a market for the or the area for their disposal. So, this is output restriction agreement. Then agreements restricting or prohibiting employment of any method, machinery or process in the manufacture of goods. Agreement providing for exclusion from a trade association of a person proposing to carry on in good faith the trade in relation to which the association is formed. Agreement providing for sale of goods at such prices to eliminate competition or a competitor. So, this may be a predatory pricing. Agreements, now under this there are two further categories: agreement restricting in any manner wholesalers, producers or suppliers from whom the goods may be bought. Agreement as to making of bids or excluding a person from making bids at an auction for sale of goods. So, this is bid rigging. Then agreements which are notified by the government as restrictive trade practices. In the last category, it is written that agreements designed to enforce the carrying out of any type of agreements which fall in any of the above categories. So, these were the categories of agreements which were registrable agreements and they were restrictive trade practices under the MRTP Act 1979 section 33. Now, let us look at RTPs which are defined under the Competition Act of 2002. So, section 3 of the Competition Act deals with anti-competitive agreements, and these anti-competitive agreements, they are restrictive trade agreements. Section 3 subsection 3 provides for presumption. There is a presumption for certain categories of agreements that if such practices or agreements are there, they will be presumed to be anti-competitive and presumed to be restrictive. So, let us now look at these restrictive trade practices, and before that it is also necessary to understand that these practices, they are between the manufacturers or the sellers who are dealing with the identical goods or they are in the similar or identical trade or provision of services. So, these agreements are horizontal agreements. Now, over here four types of categories are given. One is price fixing agreement. In this, the agreement or the practices that determines the sale or the purchase price of goods or services. So, this will be restrictive. Second, output control agreements, where the limit or the control is put up on the production, supply, markets, technical development, investment or provision of services. So, such kind of agreement again falls under the restrictive trade agreements. Then third is market allocation agreements. This is a practice in which market, sources of production or provision of services are shared by the persons or the enterprises. So, over here the market allocation can be on the basis of types of goods or the products, it can be on the basis of geographical area or types of consumers, etc. The fourth category over here is bid rigging agreements. These are the practices or agreements which are resulting in bid rigging, manipulation of the bids or collusive tendering at the time of the bids, and they may be directly or indirectly resulting in bids or the bid rigging or collusive tendering. So, these were agreements which are given under section 3, subsection 3, where the presumption as to the anti-competitive effect is there. Section 3 under subsection 4 provides for the agreements which are likely to have appreciable adverse effect on competition, and these agreements may be between persons or enterprises which are at different levels in the chain of production. So, now we are talking about the vertical agreements. These vertical agreements, they fall under 5 categories: tied in arrangements or tied in agreements, exclusive supply agreements, exclusive distribution agreements, refusal to deal and resale price maintenance. Let us now look at a tied in agreement. So, what will be the tied in agreement? Where purchaser of one goods has to compulsorily buy another good from the seller or the manufacturer which has been tied up with the first group. This will be the tied up arrangement. So, if you have to buy goods number 1, you have to compulsorily buy goods number 2. And what happens in that situation, that the manufacturer or the seller who is having a market power in the goods number 1 will use that power in order power to sell its slow moving goods at the position number 2. So, this is tied in agreement. Next is exclusive supply agreement. This is applicable to the purchaser who is acquiring or buying goods from the seller. So, when it is exclusive supply agreement, the purchaser is restricted that he has to get all his supply from the one producer, and he cannot deal with the goods of any other competitor or any other supplier or the seller. Now, in case of exclusive distribution agreement, any agreement which limits or restricts or withholds the output of or a supply of any goods or allocate any area or market for the disposal or sale of goods will be exclusive distribution agreement. So, over here the restriction will be that you are demarcating the area within which the goods will be available and where the goods will not be supplied. So, this will be exclusive distribution agreement. Refusal to deal simply means boycott. That means one buyer is boycotting the other seller, that he will not buy goods from this particular seller, or the seller is boycotting a buyer, that he will not sell goods to any particular buyer. So, this can be an individual practice or it can be practice in the amongst the people who are dealing in the vertical chain. Then resale price maintenance is a kind of agreement where the seller is dictating the price to the retailer, that he has to sell these goods on the price which is fixed by the manufacturer. So, retailer is not allowed to sell at any reduced price and give any concession or rebate on the maximum retail price which has been fixed by the manufacturer of the goods. He can do so only if he has been allowed by the manufacturer to sell goods at the reduced prices. So, these were the categories of agreements which are anti-competitive and which are likely to have appreciable adverse effect on competition. Now, any dominant enterprise or a group of enterprises, they may also become restrictive and abusive of their dominant position through the restrictive agreements. Such practices or agreements they are dealt by subsection 2 of section 4 of the Competition Act, and they include limiting production or scientific or technical development, denial of access to market to any competitor, barriers to entry and expansion of the competitors, imposition of supplementary obligations and protection of other markets. So, these are the 3 particular ways in which the restrictive trade practices are dealt by the Competition Act 2002. Let us now have a look at restrictive trade practices under the Consumer Protection Act of 1986. So, as I told you earlier that before the repeal of MRTP Act, all the RTPs and UTPs, they were dealt by the MRTP Act. After its repeal, RTPs and the UTPs, they were added into the Consumer Protection Act. So, under section 2 subsection triple N, the restrictive trade practice has been defined. It says that it means a trade practice which tends to bring about manipulation of price or conditions of delivery, or to affect flow of supplies in the market relating to goods or services in such a manner so as to impose on the consumers unjustified cost or restriction. So, over here again we are talking about manipulation of prices or condition of delivery which affects the flow of supplies in the market, leading to unjustified costs or burden on the shoulders of the consumers. And such practices, they may delay the time period within which the supplier may have agreed to supply the goods to the consumer, or providing the services in which he may have agreed to provide the services, which may lead to the increase in the prices, or they are likely to have increase in the prices due to this delay. And besides this, any trade practice which requires a buyer to buy or hire or avail any goods or services as a condition precedent to buying, hiring or availing of other goods or services will also be a restrictive trade practice under the Consumer Protection Act. Let us now come to the second category, which is unfair trade practices. Again we will follow the similar manner. We will discuss unfair trade practices under the MRTP Act, followed by the Competition Act and the Consumer Protection Act. So, 1969 MRTP Act defined under section 36 that unfair trade practice means a trade practice which adopts any unfair method or unfair or deceptive practice for the purpose of promoting the sale, use or supply of any goods or provision of any services. So, again we are using three terms: unfair method, unfair or deceptive practice, which is used for the promotion of the sale, use or supply of the goods or provision of any services. And there are few categories which are given under UTPs. First category is false representation. So, false representation, as the terms indicate, that they are representations which are false in nature. How many types of representations can fall in this category are also given by the MRTP Act. So, let us have a look at these categories. First is that there is a false representation that goods are of a particular standard, quality, quantity, grade, composition, style or model. Second, that services are of particular standard, quality or grade. Third, that any rebuilt, second hand, renovated, reconditioned or old goods are new goods. Fourth false representation, that goods or services have sponsorship, approval, performance, characteristics, accessories, uses or benefits which such goods or services do not have. So, sometimes we look into the market and we find the advertisement that where an Indian retailer is saying that his goods have sponsorship of let us say National Panasonic, whereas no such collaboration or no such sponsorship is present. So, that will be a false representation falling under this category. The next is that seller or the supplier has a sponsorship, approval or affiliation which they do not have. Then the next category gives a false or misleading representation about the need or utility of the goods or services, gives a warranty or a guarantee about the performance, efficacy, length or life of a product or goods which is not based on any proper or adequate test, makes a representation to the public that appears to be a guarantee or warranty of goods or the services, whereas such kind of guarantee or warranty is not available. It materially misleads the public about the price at which the goods or the products are sold. And last category is that it gives false or misleading facts disparaging goods, trade or services of another person. So, the competitors use this exercise, which is a false representation, when they give false or misleading information about the goods of their competitors. The second category after the false representation is offer of a bargain price for sale or supply of goods or services which are not offered to be, which are not intended to be offered. So, you are giving a bargain price where you know that you are not going to, you do not intend it and you are not going to supply this to the consumer. Third is permitting offering of gifts, prizes or other items with the intention of not providing them as offered or creating a false impression that something is offered free of cost or the charge, or conduct of any contest, lottery or game of chance, or any skill for the purpose of promoting the sale, use or supply of any goods or products or services. Now over here two cases are very important, one is of the Horlicks and another is Colgate Tri-Guard. So where two contests were used by the manufacturers of the goods. So we indicate, the manufacturers indicates that they are giving something free of cost, whereas it is not intended to be given so. So the prices they are increased in such a manner that the consumer does not come to know that there has been an increase in the prices of the goods which are offered, which they are purchasing. The fourth category is where the agreements they permit a sale of goods that do not comply with the standards which are prescribed by the competent authority, is as if they comply with the standards. So it is not non-compliance of the standards. Then fifth is which permits hoarding or destruction of goods or refusal to sell or provide any service. So these are the categories of unfair trade practices under the MRTP Act. Now let us have a look at the Consumer Protection Act. Section 2R of the Consumer Protection Act defines unfair trade practice, and it has borrowed the same definition from MRTP Act as it is, and this was amended in the year 2003 through the Consumer Protection Amendment Act of 2003, and two additions were made into this, that clause 3A was added in the definition, and which came after clause 3, which dealt with offering of gifts or prizes etc. free of cost. And clause 3A says that that where we are withholding from the participants any scheme offering gifts, prizes or other items free of charge, on its closure the information about the final results of the scheme. That means where the scheme has come to an end and we are not giving the final results to the consumer, so that they do not know who is the winner of these offers, then this will be unfair trade practice under the Consumer Protection Act. But the explanation added to it says that if in the same manner in which the advertisement was given, if the results have been announced or published within the reasonable time period, that will be taken to be sufficient compliance for the information of the buyers of the goods or the consumers of the goods. Another clause which was added was clause 6, which talks about spurious goods and services. Now what are spurious goods and services? These are goods and services which are claimed to be genuine, but they are actually not so. So clause 6 says that manufacture of spurious goods or services or offering such goods services after adopting deceptive practices in the provision of services, that will be unfair trade practice under the Consumer Protection Act. Now come to the unfair trade practices under the Competition Act of 2002. Now section 4 subsection 2, which deals with the dominant enterprises or abuse of dominant, it says that a dominant enterprise or a group may indulge into unfair or discriminatory trade practices, and it may impose unfair or discriminatory conditions on sale of goods or rendering of services, or unfair or discriminatory price in sale or purchase, including predatory price of goods or services. Now over here the enterprise or the group is abusive of its dominant position, and it is giving unfair burden to the consumers. Now over here the practices, if they are adopted for the pro-competitive effects, then they will not be anti-competitive. So such type of unfair practices are not per se unfair, but rule of reason has to be applied in order to find out whether they are having anti-competitive effects or not. Now over here the predatory pricing is a pricing where the manufacturer or who is having a dominant position in the market is selling goods at such prices where his competitors are not able to sell on those prices. So in a way he is eating up his competitors. So that is why the word predatory pricing has been used over here. So we can at the end we can conclude that Competition Act, since its scope is different, its applicability is different, it is not directly applicable to the consumers. It deals with business to business transactions and business to business agreements. It deals with ex ante issues, that means it deals with behavioral issues of the market players. So that is why the remedy in the hands of the consumers is not directly given by it, whereas Consumer Protection Act is reactive in nature. Once any loss is felt or injury is felt by the consumer through the restrictive trade practices or the unfair trade practices, only then the consumer can go to the consumer protection redressal agencies, and the instruction can be given by the consumer redressal agency to the manufacturer or the seller who is indulged into RTPs or UTPs. So it gives directly remedies in the hands of the consumers. So this is what we need to understand, that although we are referring to the Competition Act also, but the scope and the applicability of both these acts and the remedies which are provided to the consumers are different under here. Let us now take some cases on RDPs. Now, a few recent cases where RTPs and UTPs have been decided by the Competition Commission of India. The case of DLF, where apartment buyers agreement was found to be unfair by the Competition Commission, because all the terms they were one sided. This was an agreement which was one sided agreement, so it was unfair to the consumers. Whereas in the case of cement cartelization, where the cement manufacturing companies, they were found to be indulged into price fixation and also having a control or reducing the production capacity of the cement manufacturer. So in both these cases, the entities have been fined by the Competition Commission of India. Let us now take some examples of MRTPC, the cases which were decided by the MRTPC Commission. So in the case of Bata Company Limited, this case was decided in 1976. Bata Company had made agreements with the small scale producers of footwear and had restrained them from purchasing raw materials or other supplies from parties other than those which are approved by Bata. So the small scale manufacturers who were dealing with the Bata, they were restricted that they should get their supplies only from the those manufacturers or the raw material suppliers who are approved by Bata. So this was found to be restrictive trade practice. In the case of in reference Radhakrishnan International School, this was decided in 1992. In this case, students were forced by the school to take at least one full booklet which consisted of fate tickets consisting of at least 20 in one booklet, and each ticket was of ₹5 each, where the students were forced to pay the unsold tickets as a part of the school fee, and this was found to be RTP. The next is the case of Erlanger Motors Incorporated versus Ford Motor Company. This was decided in 1959. An automobile manufacturer he had his franchise agreement in which he required his sellers to exclusively handle the manufacturer's car parts and the accessories. So this was found to be restrictive trade practice. Now two cases on the unfair trade practices. One is in reference Vijay International Products. This was an inquiry of 1984. In this case, respondents, they were manufacturing and marketing stoves which were sold under the brand name of Nutan, and these stoves were designed by Indian Oil Corporation. They were sold without any competent authorities inspection and clearance, and this was the stoves that were marketed were substandard stoves. So this was found to be an unfair trade practice. Another is an inquiry of 1988 in reference Shriji Chemicals Limited, where the company had offered a free toothbrush with a pack of Vimal washing powder under a sales promotion scheme 1985 from April to September, and company had increased the prices of the detergent during the scheme in order to avoid giving anything free of cost, and it was found to be unfair trade practice. So in this module we have discussed about restrictive trade practices and unfair trade practices, what these practices are, what are their effects on the ultimate consumers, and how they are dealt by MRTP Act, Competition Act and the Consumer Protection Act. Please remember that MRTP Act 1969 has been repealed, and after its repeal, these provisions have been brought under the Consumer Protection Act of 1986. Thank you very much.